One of the biggest factors that people often don't really think about that can influence custody is how well the parties are able to communicate. Obviously, if a relationship isn't working out, there's probably a breakdown of communication to begin with. But if it gets to the point where the communication is so toxic and so volatile that the parties can't work together, maybe they can't communicate without one person completely disparaging and putting down that other person. Maybe it's a situation where one parent is talking to the children and constantly putting down the other parent. In those cases, a judge will take that into consideration. And if you're looking for a situation where you can co-parent and you want joint or 50-50, make sure that you're able to effectively communicate with your spouse, because if you can't, you might not get it. If you have a co-parenting agreement that at this point you've tried and it's just not working, you have the right to go back into court on two different actions. One, if it's very clear what was laid out within your prior order and the other person is not following it, you potentially have what we refer to as a complaint for contempt. And that's going in telling the judge that the other person isn't following what we're supposed to be doing and asking for some sort of order to be issued to either make them follow it or to change it so that they can follow it. Another thing that you can do is file a complaint for modification. And that's asking the court to change what that order is because it's no longer working. So those are your two options if what you have no longer is working for you and your family. Common question we get is, at what age can my child decide who they want to live with? And in Massachusetts, your child will never get to decide who they want to live with. Now, their desire can become a factor, and it's usually a stronger factor at the age of 14. But that does not mean they have the right to choose. So please don't put your kids in the middle and say, who do you want to live with? Because number one, if that goes to court, the judge is not going to be happy to hear that. There's situations where, let's think of a typical 16-year-old. They usually just like to play video games or be on their phone. And if it's a situation where the parent is saying, oh, if you come live with me, no problem, no rules, no nothing, of course the 16-year-old is going to want to go live with that parent. And that's why a child doesn't actually get to pick who they live with. The court is always going to take what they have to say into consideration based on their ages. And then the court, if the parents can't agree, will make the decision as to where your child lives. If you have a court hearing coming up on your custody matter, make sure that you're prepared to head into court. If you have an attorney, talk to your attorney so that you understand what's going to happen. Typically, if it's a motion for temporary orders, you're going to get into court, you're going to have to go to family service and try to negotiate an agreement. If you're not able to negotiate agreement, that argument is going to come in front of the judge, and at the end of the day, the judge is going to make that decision. However, they're not going to make the decision usually on the same day. They'll do something called taking it under advisement, which means you will get the order in the mail probably within anywhere from 2 weeks to 6 weeks. Before your court hearing, make sure that, especially if there's any allegations of alcohol or substance use and abuse, make sure, even though it might be stressful, you might be nervous, do not pick up a drink, do not take a drug, do not do anything, because the judge can potentially send you down for testing that same day. And if one person is making an allegation, usually the judges will send both parties down. So even if you don't have the issue and the other side has the issue, if you do anything that can put yourself in jeopardy, just don't do it. Another thing to remember is that the court process itself can potentially take all day. The court breaks from 1 o'clock to 2 o'clock every single day for lunch. And a lot of times your case is going to be over by that lunch break. But don't plan on it. Plan for if you have kids and they have to be picked up from school, make sure you have childcare available for them, because the last thing you want is that additional stress as you're getting ready to go in front of the judge because the negotiations have broken down. The last thing you want is the stress of trying to figure out who's picking your kids up from school. So have a backup plan. Also, don't plan anything for that night, because anytime that you're walking into court, it's going to be stressful. And even though if you have an attorney, they're doing all the work for you, the stress and the tension that can come from just sitting in court all day can be completely overwhelming. So if you've planned a night of activities, you're probably not going to be up for it. take the day off from work and just relax and give yourself a huge A+ for actually getting through court. So those are some of the things that you can do to prepare yourself and understand what's going to happen if you walk into court on a custody issue. If you're looking at a custody case, whether it's initially or you're trying to modify something, please feel free to give us a call. We'd love to take you through a free case evaluations to really look at what your goals are in your particular situation and the strategy that we can come up with to get you where you want to go.